So hi, I'm an independent non-executive director. I'm on a number of boards. I've been on the public sector, challenger bank, medical firms, quite a mix really across sectors. I often chair risk and audit committees, and on some of those I've become personally accountable for operational risk issues such as data breaches. Some of these are really quite important to me. I'm also an advisor to the Financial Reporting Council as a regulator which owns the Corporate Governance Code and all the Audit and Assurance Codes, and I've been part of a coalition that's written the first ever risk guidance for risk committees as well.
Thank you, Brian.
Hello, my name is Christelle Caudelebar. I'm a dual qualified French and English solicitor. I have been working in data protection for about 20 years and closely with both the French regulator and the UK ICO. I'm currently Global Data Privacy Officer, but also board-appointed Data Protection Officer under GDPR for a large international business travel management company.
Thank you, Crystal.
Hi, I'm Will Richmond Coggan, solicitor working in data protection again for quite a long time, not quite 20 years, but certainly probably 15 years or so. I generally work with a range of businesses from sort of startups through to multinationals, but where there's a sort of tech overlap with data protection, sort of innovation, new technology, and doing quite a lot at the moment with sort of deep tech, AI, and facial recognition and medical research, things like that, the sort of data protection aspects of that.
And that's our panel for today. The subject, or the topic, I'm going to read it out because it's a very long one, but it's data subject rights, risks, controls, and finding the balance. How do we make this really work? So, significant impact of GDPR adoption in 2018 appears to have been a step change in the public awareness of personal data as an issue, and of the existence of the wide range of rights that are conferred on data subjects by the legislation. Requests for subject access, erasure, data portability, and corrections are becoming increasingly commonplace as a result. But as more and more data subjects look to exercise those rights, what are the practical implications for them and for the businesses that control their data? Can data subject rights be used to find grounds for litigation or weaponised to put pressure on business as a form of activism? What's the right balance to strike? Grappling with these questions and more, our panel of data protection experts, risk experts, bring a diversity of perspectives to this discussion. Now, you were all asked to put in some questions to help formalise and challenge our experts. And we've got a number of questions here to drive some of that conversation. But guess what? It isn't us telling you. We're going to be coming out amongst you and asking you for some questions as and when the topics allow. So be prepared. Otherwise, I'm going to pick on some people. Right. So one of the things that came out was weaponising. Can people use them as a weapon? How might they use them as a weapon? And what can we do about it? How can we get the balance right? I think, Will, you talked earlier about some of the situations that you've met.
Yeah, so when we talk about sort of weaponising subject access rights, it's important to sort of understand that this is relatively unusual, but it is happening, and it's something that businesses need to be sort of prepared for. The most common implementation of it that I've seen so far is around subject access requests. And this is where an organisation has fallen foul of a sort of pressure group or a section of the public, section of their customers or members, and those individuals decide collectively that they're going to inconvenience that business put pressure on it to try and change behaviour. So recently, a gaming company in connection with the Hong Kong protests, who sanctioned one of the esports competitors in their competition, and there was a group on Reddit who started organising to try and collect and put together a range of subject access requests from all of their customers in the European Union. They were going to be hit with all of these requests over a very short period of time, putting them to considerable sort of expense and inconvenience in having to sort of answer all of those requests. So that's probably the sort of most commonplace way in which you see it happening. But, I mean, you could say that some of the activity that's starting to happen around collecting class action litigation for data breaches, around things like the British Airways data breach, Marriott, things like that, there's definitely a drive towards locating a pool of claimants and bringing litigation on their behalf against those sort of customers.
So can I say, as an independent director, obviously you see these things happening, and although the numbers can be quite small, the attention senior executives have to pay to them can be quite significant, because they're often related to, say, as you say, activists, employment tribunals, investors that have lost money, all sorts of situations which can be quite high risk and need sensitive handling. And one of the things I ask is, what's the worst that can happen? And we need to plan for that and get on top of the risk. It's really important that it's not hidden under the covers, that people are working away on a SAR, and then you suddenly find it's leading to a big legal case, and you didn't know anything about it, or a regulatory case, or a complaint, because you didn't handle the SAR well, and you get onto the back foot pretty quickly. So you do have to look at these incidents very seriously and make sure you're right on top of them. Now, right throughout today, the conversation has been both sides as well. It's not just about you being an internal protector of the company, it's about you being a citizen too. Maybe some of you have raised SARs and you want them handled well, and sometimes they can be weaponized. So for example, I know a company that helps people do complaints to parking companies, and we know that parking companies aren't always fair to the consumers, and sometimes we might be on the side of the consumer. And often SARs can help resolve issues. They can even be weaponized by saying, if you just drop this fine, we won't even bother to take the SAR. So look at it from both perspectives, so you can see why people might be raising SARs or weaponizing them against you, and see if you are being fair to them as well.
Yeah, no, absolutely. I think, personally, I think that we tend, in corporation and, for example, vis-a-vis employee SARs, we perhaps tend to use that terminology, weaponization, a bit too quickly. It is, yes, there are certain cases, but really, they're very narrow. And I think it's about accepting that there's this new right. It derives from Human Rights Convention, more than 50, I think it's about, 70 years ago, at least. It's a human right. We have to accept it. Generally, there's something that motivates a SAR, some sort of, not conflict, but something that can become close to that. And it's really about making sure that there's a fair response and a process and everything. And those SARs that are really used as a weapon, they can be dealt with by a company to push them aside or to manage.
Yeah, agreed. And also, I think if you are operating in a space which makes you more likely to be the subject of that sort of attack, then you need to think, going into it about developing the structures, the processes that you're talking about. Facebook, not necessarily anticipating being attacked, but certainly anticipating a very high quantity of SARs. They've put in place something where you can effectively request it at the push of a button, and the process is automated. They can draw together the information and provide it to you. Google does the same. Now that's very sensible to do if you're of a scale of those companies, and if you're going to get the volume of SARs that makes that a worthwhile investment of time. For most businesses, it won't be. But if you operate in an area that's high risk, either because of profile, because of sensitivity, you do something controversial, you know, you're an animal testing company, you know, you're a political entity, you know, then you've got to anticipate that this is one of the ways in which people might come at you, and you need to organise your systems appropriately to be able to respond to that.
Brian, you brought up that subject about, you know, I could maybe raise a SAR and get away with my parking fine. But, I mean, that's probably a good business management decision to do that. But where do we stand on the legality of that?
The legality of it? Well, I guess from the lawyers should answer that maybe, but the people suggesting it probably aren't making an obvious threat that you trade this off for that, but they're doing it in perhaps an implied way. I'm concerned, as William was, that you get into that position in the first place. You know, one of the companies I work with is an ethical parking company. There are many other companies out there that are very unethical. You know, they are deliberately creating situations where fines are outweighing the money they get from legitimate parking purposes. So they deserve that type of attack, in my view. So I think for direction, we need to go back to what is the purpose of this organisation? You know, is it an ethical organisation? How does it operate? Who are the stakeholders that are both for and against you? And then you'll start to understand where your risks lie and can head them off. And if you're running unethical operations, then you know, maybe you're in the wrong, you have the wrong purpose. Or if you're determined to do that, then you're going to face some very different risks.
And Will, where are we on this sort of?
I mean, the legal position in a sense is simple, which is that everyone has the right to make these requests. And, you know, once made, that's a request that has to be complied with, unless, you know, the very narrow sort of criteria that let you off in terms of if it's sort of excessively onerous. But that means more than just it's going to put you to some hard work. It means really that it's not practically possible to do within the sort of timescale that you're being given. Now, having made the request, it's equally permissible to withdraw the request. So, and there's nothing in principle to sort of say that you can't dangle that possibility of withdrawal of the request in return for something. But, you know, just as one of the issues would be, I suppose, that it might suggest that you weren't genuinely seeking to exercise your rights for the purpose that the legislation intends, which is to know what's happening with your data. If the sense was that it was really being used as a blackmail chip, then the likelihood is that might give the organisation grounds to refuse to do it.
And also, if you made a complaint to the regulator, or if it ever went to court, chances are that they would be less likely to want to see it.
It begs the question about the DPO role, because there you've got business operational management challenging and saying, actually, from a business perspective, we'll let the fine go, but the DPO actually has to say, no, legally this is where we are, unless we get those written consents to say, actually, they're going to drop the SAR. So have you got a comment on this, Crystal?
I would not advise the company I work for to pay or offer money to an individual to drop a SAR personally, because that would, from a business standpoint, although, yes, I completely see, you know, some explanation behind it, but that really sets a precedent. Do you want to be known as the company who pays off individuals who are making a SAR for whatever reason? Because you don't have to say why you're making a SAR. So if we're saying they're weaponizing this, it's a blackmail fact, you know, that's for us to prove. Paying off somebody on the assumption that they're using it for reasons that we believe are the wrong reasons is not a good idea. So I would really not go down that road.
I'm also aware of companies that get a lot of SARs that they believe are fishing expeditions. And absolutely right. The people have the right to request them, and you have to take them seriously. So you have to preempt that that's going to happen, and you have to have good processes in place to manage them. Full stop.
So another question from our audience was, there has been a growing area of SARs in employment disputes as a means of causing a company additional work. Does the panel believe this area needs to be addressed and rules put in place to stop malicious SARs? Shall we start with a legal perspective?
Yeah. So, I mean, I do see this fairly frequently for clients of mine who are employers. It's an interesting one for a couple of reasons. Firstly, yes, sometimes the sense is that they are motivated maliciously, but it's almost certainly a bad idea to reject it on that basis. If this is someone who's a sort of disgruntled former employee, or they're on their way out the door, the idea that you'll just try and shut them down, or that you'll be able to shut them down just by refusing to respond to a SAR, is probably ill-advised. You know, if anything, you're giving them another way of attacking you, because they can then complain to the regulator that you haven't allowed them to exercise their rights. The converse of this is that actually when people find out what you can provide, or what you're required to provide under a SAR, often it's a lot less than the person making the request thinks. Often they will expect that they're going to get every document in full detail that the organisation holds. When they realise that actually they're getting documents that are potentially heavily redacted, or they're getting only the extracts that contain specific personal data relating to them, often that's a lot less valuable to them than they were expecting. So once that education piece has happened, firstly, they're probably less eager to pursue that avenue, but secondly, actually, the business will be much more comfortable providing it, because it's often not as harmful or onerous as they were expecting it to be.
So this is about personal data, and there is a natural imbalance between an employee who has a grievance, or a whistleblower, and a big company. And to some extent, the regulations try to address that. So for example, if you leave in a dispute, I think you have something like 3 months to register and start an ACAS claim. It's quite likely that during that time, you're not going to make much progress on the legal disclosure process, whereas the company has to complete a SAR process within 30 days. So, you know, if you look at the individual's rights and the rebalance of their rights against a big company that could force them to perhaps take legal advice, to go through a legal process that they couldn't afford, it does allow the individual to press their rights. So the company, I think, has to, again, be fair, to look at that and decide how it's going to handle it, so that it's fair to those people. But they, you know, if you don't do that in advance, then you can end up spending a disproportionate amount of effort on those things. And if, for example, you redact data and you do it badly, then that can come out later in any legal case against you. So you need to be on top of these things, but you need to be fair in the way you set them up.
Yeah, I mean, from my experience, professional experience, I think where it starts getting tricky is not so much the usual personnel files or PI related to personal files and your contract, and even to some extent your performance, your appraisals and documents on that. HR can find these quite easily and provide these in a SAR. When it gets tricky is when the employee is requesting, so for example in the UK, for emails or any comments and notes that accompany particularly disciplinary procedures, because you're supposed to also provide those in a SAR. That's when things get really tricky, and where HR typically goes to the DPO, at least at first, and says, well, what do you have to provide? Every single email for that employee who's been here for 20 years. And so there are practical steps to take. And what we found, and there's many others, but is to really try and narrow down the search. So be in an active interaction with the requester, be very, very, respectful, and not make that person feel like they're really asking for the moon, and say, well, listen, these are the keywords and the search that we think is what you are after, and generally the company has a good idea of what that employee is after. Can you, sign this off? And I don't know what you think, but
I agree with that. I mean, there's sort of two things. One is always very unhelpful to hear at the point at which you're dealing with one of these, and that is that if you're in this position, you needed better systems a year ago. When you need to make sure as an organisation that you're setting up the methods of communication, the channels of communication, the way in which data is retained, how long it's retained for, all of that with a view to minimising the extent to which you're going to have to give damaging disclosures as part of a SAR process. Often businesses will sort of retain all of the information about staff until 6 years after that staff member has left. Now, that's carrying a long tail of a lot of data about that individual, some of which you really don't have any particular need for anymore. If you've got a disciplinary policy that says, well, we can take account of previous disciplinaries on the same subject in the last 3 years, why would you retain information about a disciplinary from 6 years ago? If you've got requirements around storage of external communications that only goes back 6 years, why would you keep internal emails going back 20? There's often a big batch of data that ends up having to be processed in these requests that you really didn't need to have. But if you've got it at the point that the request lands, it's caught by it, and you're going to have to deal with it. So, that's one element. But the other thing I would say, if you are narrowing the search, which I agree is a really sensible way to proceed, make sure that you're engaging with all of the parts of the business who might know something relevant. And I say that because if you subsequently end up in litigation, the disclosure obligations that you're subject to then are different to what's caught by a SAR. And if you innocently, so let's say you come back, you say, okay, I'm going to search our Exchange server, I'm going to search our document management system, I'm going to search, storage in the cloud for these keywords. And it turns out that actually 2 of your managers were having an exchange on WhatsApp about how to get rid of this particular individual. That won't be caught in your searches. What you can't afford is for it to later look like you deliberately define those searches in a way that would exclude that relevant evidence, because it will be disclosable in the context of subsequent legal proceedings. So making sure that you've established that when you draw those parameters, you're doing it in a way that's not going to come back and bite you, or to put it another way, that's actually genuinely sort of fair to the data subject. I think it's a really important part of that dialogue. But I agree totally that it's sensible to try and reduce the burden if you can at that point.
Can I just focus in on this specifically says about rules put in place to stop malicious SARs. So what is a malicious SAR? Is it one that's too extensive and doesn't bear any relationship to the case? Or is it that the SAR's repeated too soon after the last one? What makes a malicious SAR? But generally, the default for the regulation is that it's there to protect the individual against the company. It's about their personal data. And so that has to be the default position.
Yeah. Is the person who raised that question here and willing to perhaps give an example of what they mean by a malicious SAR?
I'm not that person, but I remember this conversation from 12 months ago.
Yeah.
We have a lot of disgruntled ex-employees
Yeah.
in a small market town up in Lancashire, and it is the default thing that they do when they leave the contact centre is they submit a SAR, and I educated them on their rights in May 2018 because that was part of what we're doing. Is as a data subject, we're looking after your data. This is one of the elements, and now I'm the one that is receiving these SARs. We're a relatively small business, we're relatively light in administration, and in terms of maliciousness, the data structures. So I've got a process. We go to our record of processing. Look down there. That's all easy except for email, because that email is unstructured data, masses of it, that all requires redaction. And I was wondering if we're almost coming up to 2 years down the line, if the ICO or some other best practice was now coming out about how organisations can deal with this. It's a problem. It's a genuinely a resource-hungry problem, and I don't believe they're doing it. You've got data protection professionals, or data privacy professionals in this room who care about privacy, and I don't believe that these individuals are raising the requests with the same ethic.
I think we come back to the same points, to try and preempt, to try and put processes in place, try and separate data. Retention characteristics are key. Are you keeping things you don't need to keep? But eventually there are complexities, and you mentioned, for example, emails where you need to redact them because there could be private data about somebody else in there that you need to remove before you release it. So there are some things you can do, there are some things you can't.
Yeah, I would say that there are the emails, and we're talking about that actually because it is a subject, a very relevant subject. So there are emails where you only have the email address of the disgruntled employee and nothing really about that employee in the email. So that you don't, that's out, okay, out of scope. And in terms of the what we can do before, now that we're wiser, it's probably really train HR and others, the whole company. Do you really need to email or IM each other about John's, I don't know, bad habits at work or bad behavior, whatever? Do you really need to email or can you just face-to-face discussion or even call, unless that call is recorded? Do you really need to email? So.
But what that does is that moves the business conversation onto non-business platforms. You mentioned WhatsApp, because in a litigation, people are, there's no WhatsApp. No, we don't WhatsApp. There's no WhatsApp messages there. There's no trace of it. There's no record of it. And that's the business problem that the SAR rules have brought in. So if you're trying to do a business reorganisation and you've got some changes that need to be implemented, that need to be planned, need to be considered and debated amongst the senior management team, there will be emails, discussions, pieces like that that's needed that would be cut, that will have people's names in as part of the SAR. And there was some criteria under the 1998 registration, I think it's still in the GDPR regulations now, about you don't have to disclose certain, mine's gone blank, but there is something about, but we tried and we weren't able to hide that information as part of a recent SAR request.
You do also, I'm trying to find ways to not disclose. You can also use that balancing test. So for example, you'll have, particularly for emails around senior executives appointment or de-appointment. So it will involve someone else in the discussion, and you need to protect the privacy of that or those other persons. So you can take a little bit of a risk-based approach, but that at the end of the day, that's the legal approach, and say, well, actually, I'm not going to disclose that email because 2 other people or 3 or 1 are mentioned. We need to protect them, and on balance, it's not fair to disclose, because even redacted, that person, everybody knows who this is.
On the you said about disgruntled, and you also talked about transformation. Certainly when I've been doing transformation, one of the things that we've had is requests for who might be going, and that can cause a little bit disgruntled. We always put it down to the roles, and the actual specification of the roles we did much later in the process. But we also had to do that with the unions as well, to make sure that the unions were aware of what we're doing. So that might be an approach that you can use.
Thanks. It's just going back to the repeated requests point. So there is that paragraph in the GDPR saying you don't have to necessarily comply with a data subject access request where it's manifestly unfounded or excessive. When the GDPR came in, we were all waiting for guidance from the ICO on what that would mean, and it's still not there. I was just wondering in the panel, has anyone been brave enough to test that water when you've got repeated requests? Because really, until the ICO gives guidance or says, no, that's not a manifestly unfounded or excessive, we're saying you've got to comply, but you do get repeat requests all the time. And, well, personally, I'm not brave enough to tell a client to say, actually, yeah, you don't have to comply with it, but in the absence of guidance, has anyone actually tried that line?
Yes. The couple of things. I mean, one, probably quite a useful yardstick is to what extent is your answer going to be the same as it was the last time the request was made. So if you've got someone who is, for example, still a member of staff, and it's a year later, there might be significant quantities of new information that falls to be provided. You certainly would probably go back and say, I'm not proposing to give you anything older than 12 months because you've already had that for the last request, but there's going to be new stuff there. If they're an ex-employee, the likelihood is that the only stuff that now exists, that didn't exist a year ago, is information related to their interactions with you the last time around, in which case you're not really going to be giving them anything new. And I think in those circumstances, you could say relatively comfortably that that's unreasonable. It is unlikely that you will get any guidance that you can hang your hat on from the ICO. They will be very careful not to do that. It will have to be tested through the court, I think. And that means that it's 6, 12, 18 months before you're really going to have any proper clarity on that, I suspect.
So, I do work very closely with regulators, and I'm on one myself, and the ICO is far from the worst. And I would agree with Will's approach that, you know, if you take a practical approach with some logic behind it, properly document it, then, you know, if they come and look more closely, the chances are they would more likely agree with you than not. You're not completely safe in that, but I don't think that's a bad position to take.
Do we have another question? Oh, and one there.
I just want to pick up on the phishing comment before, because I work for a financial services company, and one of the things we've seen is solicitors using blankets, so they will get a blanket authority from their client, and then flood every financial services company that they've ever had any interaction with. And we're seeing that more and more, and that's taken up a lot of our time. And I wondered if, you know, had any sort of comments or experience of that.
So, I don't think that's phishing as such, because you can go to a lawyer and say, well, you know, I'm instructing you, why not? You know, I want to pay you to make a SAR on my behalf. You can absolutely do that, and you wouldn't be think that's not phishing. So, so long as the solicitor has the right to represent, of course, an individual, they could do that, and even, you know, gather a whole assembly. After all, I mean, you're.
It is important to understand the distinction between disclosure and SARs. Disclosure gives you a lot more information, but you can only make an application for disclosure if it's in the course of proceedings, or if you've got a claim that you're about to get off the ground and you need that disclosure to help you to bring your case. So there, the concept of phishing is really relevant, because you can't just make a blanket request for anything that you might find useful. You have to frame it in the context of, I have a claim for this remedy, and these particular documents will assist in that. Anything outside of that is dismissed by the court as phishing. With a SAR, it is completely permissible for the data subject to write to every organisation that's a controller of their data at the same time and say, I want everything you have on me. And no one is allowed to say, well, you're making a lot of these requests, I question your motives, I'm not happy to provide that. That's not how the right works. It's a blanket one. And so it's problematic, but that's, as an organisation, this is why we keep coming back to this point, you need to be ready for that. You need to structure your business in a way that anticipates that these requests can be made and will be made, and only hold data that you need to, and only hold it for as long as you need to make sure that that's no more burdensome than it has to be. But it is a burden, and at the moment, I don't see any likelihood of that burden being reduced.
So while I would support the rights of individuals to create proper SARs, these things can be misused. And I'm afraid the direction of travel I see is exactly as you say. There are adverts on the radio at the moment saying, if you've ever been told to invest money by anybody and you've lost it, the chances are you can get some of it back, which is probably completely untrue, but creates a lot of that general direction. And if that's the general direction, then we're going to have to be prepared for it.
And we have a question from the lady over there. Thanks, Robin.
Hi. We have had some conflicting advice in relation to the level of ID that we should seek before we process a individual right. The ICO told us we shouldn't request anything that we don't hold. Our auditors told us that we should always ask for, so we don't hold photo ID. We don't hold the photo of our member base, for example. Whereas our auditors have told us that we should always be asking for one of those, a copy of one of those very official documents, like a passport or a driving licence, before we, for example, provide subject access data. Just to give you a kind of example, we hold data that could give, if we got it wrong, we could give away the location of a family that may have joined our organisation as a family but have since split. We work on a pyramid of risk. We work on a worst case scenario of what could be the worst that would happen if we gave it to the wrong person. Somebody who knows an awful lot about the person they're asking about and possibly has copies of their documentation. So to what extent should we be as careful as we feel that we are rightfully being before we disclose somebody's data if we're not confident about their identity?
I mean, I'm sure all of us three will give you a little bit of guidance. I mean, I think that you should go with what the ICO is saying. I have heard, I have read the same guidance from other regulators in Europe. So asking for an ID is, and there's been floating debates around this. Before it was yes, ask for an ID, absolutely. Then it was no, and now it seems to be don't ask for an ID unless, unless really you can. It makes sense, yeah. But recently there's been guidance around asking for a piece of information that you hold, of personal information that you hold, and that will identify that person. So I'll give you just one example. So you could say, okay, so John Smith made a SAR. Can you give us, roughly the last, date that you interacted with us, something along those lines, or even roughly the county in which you reside for identification purposes.
So, the reason this guidance has been evolving is because of the fact that a lot of people have been using request for ID as a stalling tactic or as a barrier because they can't charge the £10 fee anymore. So they sort of come back and say, oh, well, you've got to come into a branch and you've got to present a copy of your passport or driving licence. And they know that a certain number of people will just not bother. So the way the guidance is structured now is that the starting point is you don't ask for ID unless you've got a reason to doubt that the person is who they say they are. So if you've got a very straightforward, you've got an employee, an ex-employee who has left the business, they've provided a forwarding email address, and from that email address a request is made together with some information that correlates with their employment. Why wouldn't you just sort of accede to that request? But like a lot of things in GDPR, it's risk-based. The greater the degree of risk that goes along with a wrongful disclosure, the more precautions you ought to take. And the scenario that you're describing is one where it doesn't seem at all inappropriate to take a relatively high degree of care. Whether that always means photo ID, I wouldn't think it does. But I agree exactly with what Crystal says. There will be information that you can ask for with a bit of thought that you can use to satisfy yourself that this must be the person that you think you're dealing with, and provide the information accordingly.
Yeah,
So
just to say on that, the cases I'm talking about are where we have concerns. There doesn't seem to be any link between the person who's asking, like the email that comes in. We've got just that feeling that something might be odd. It's that sort of level, really. So,
as a director, I have ultimate accountability, and whether the regulator says these are the rules or not, I retain the accountability. And so the risk-based approach is the right one to take. And I can see exactly what you're saying. I was on the board of the Child Support Agency. For 3 years we had those situations where if you release the data to the wrong people, then terrible injury could take place, all sorts of assaults and problems. You had to protect those people because we have to be very aware of risk and harm with the use of data. And I would stand behind that and override, take your own view on the regulations and support that later. We are expected to stand up for our judgments in court. We must do that.
Okay. I'm afraid we've finished. We've run out of time. I'd like to thank our three panellists for speaking, and in the usual way, well done.